Are you dealing with a probate issue right now? Well, you're going to want to watch today's video because I have the luxury of being here. I'm at Dorsey Law Firm. It's an amazing organization, but I'm going to be meeting with both Josh Dorsey, who's the partner, founding managing member of Dorsey Law Firm, and Doug Dotson, also a partner here. And we're going to do a deep dive into what you need to know about probate, especially here in the state of Florida. Let's jump right into it. Well, guys, thanks so much for coming on. Really appreciate you guys taking the time out of your busy days, busy attorney days. And, the subject for today is one that I just am super excited about. Not because the subject matter is that exciting, but it's because there's so much misinformation out there. And I wanted to bring this video to you because if you're going through a scenario where there is probate involved in the state, these guys are the best. These guys know the ins and outs of everything. And so I wanted to get a good baseline on it. So Doug, Josh, thanks again for coming on.
Of course. Thanks for having me
here. So my first question is, let's just start from the very beginning. What is probate?
Okay. Well, when someone passes away, their estate needs to go through the probate process. It's something that's overseen by the courts, just to make sure that all of their assets that are just in someone's name are distributed appropriately. Any final expenses of the estate are taken care of through the probate process, and things are held and distributed to the beneficiaries at the end of the day, and everyone's happy.
Okay, and is that, so we're in Florida, obviously, is that the same state by state, or is Florida?
It varies from state to state, just as far as the different rules and the timelines, things along those lines. For real estate, it's fairly similar for most states, but there are some particularities in Florida that are a little unique just to our circumstances.
Okay, got it, and we'll dive a little bit into that. So, Josh, is there a way people can avoid probate?
So typically there's two standard ways that people can avoid probate. One is they can use beneficiary designations, or sometimes you'll have, like at a brokerage house, you'll have a transfer on death certificate, or maybe on their life insurance or IRAs or annuities, they'll have a beneficiary designation. Their checking account and savings accounts would have a payable on death certificate. Those are ways to avoid probate. We wouldn't typically recommend that people use that as their primary purpose. Probate isn't always our biggest concern. Sometimes it's taxes, sometimes it's asset protection for the heirs, but it is a way to avoid the probate process. Another way to avoid the probate process is by using some form of a living trust. We believe the Florida Revocable Living Trust Act is very beneficial to individuals, and really it's the way the state of Florida has allowed for people to avoid the probate process and at the same time allow for tax efficiencies and asset protection for the heirs. Mm-hmm. And so the preferred choice to avoid probate is typically a revocable living trust.
Obviously, that needs to be done in advance while somebody is still living. And so if you're watching this, and chances are you may be going through a probate process, but it's also a good reminder to be able to potentially get those trusts set up for future.
Yeah, they're amazing tools. They work when people are disabled. They work when people have passed away. So they're amazing tools. But as we talk about probate today, I don't think there's a better tool out there, especially statutorily, to allow people to avoid the probate process.
Okay, and the word process has been used quite a bit by the two of you so far. And so what does that process look like? I get the question very often, how long does probate take? And I know that can be a challenge for some people.
Oh, sure. Of course, like any attorney will tell you, it depends.
Yeah.
Gosh,
you're such an attorney, Doug.
Nailed it. Usually they range between 6 months on the very lucky short end of things, up to a year to 2 years, just depending on the complexity of the probate estates you're managing. Okay. Roughly speaking, essentially, someone will be appointed as the representative of the estate. They're called the personal representative. At that point, they have full authority to act on behalf of any of the assets of the estate, to settle any final expenses, deal with all the affairs of the estate. In Florida, there's a notice to creditor period, which gives creditors 3 months to file claims against the estate. So that right there is a long waiting period for a lot of estates. You have to wait through that creditor period to see who comes forward. And then dealing with those creditors can take 2 weeks, could take 4 months, depending on the creditor. Mm-hmm. So there's a lot of variation just depending on how someone's affairs are structured before they passed away.
That makes sense. And so the personal representative portion that you're talking about, because it's a real estate channel, we talk a lot about the real estate component of things. When does that happen in the process? When does that person get designated and they can start talking about the real estate?
So typically, it's the first document that we receive from the court after we submit initial documents.
Okay.
So the first step is to tell the court you're looking to go through the probate process because you have assets that need to be probated. Mm-hmm. The judge will review kind of our initial petitions, and then sign off on an order saying this individual, usually a family member, is now the representative of the estate, and they can handle all the affairs accordingly, sell real estate, for example, and things along those lines.
Okay, got it. And if we take it back one more step, like how do somebody passes away? Mm-hmm. We know, let's say that they're, are a widow, or they didn't have a joint tenants in the real estate, or, they tenancy by the entireties, and it just goes directly to husband or wife. What is the first step that people should do? Like, what's the very first step that people should do?
For any probate proceeding, the first step is usually just to reach out to your attorney and sort out from them exactly what assets you're talking about, particularly with real estate. A lot of times it's going back to the currently recorded deed and just kind of verifying there's no remaining owners on that property. So from there, you'll know essentially that property needs to go through the probate process, and then you can talk with your attorney as far as what the steps are required for that. There's a few extra steps if there's no will in place. So if you don't have a will, it's called intestate probate. From there, there's additional orders that the judge needs to sign in order to sell the property if that's the goal. Also with Florida, there's something called a homestead exemption. Yep. So if it's someone's primary residence that's going through probate, for the most part, it's exempt from all creditors. So those properties will go directly to the beneficiaries. So getting down into those details is best done, directly with your attorney, just to kind of make sure you know what the plan is for each particular piece of property you're talking about. Got
it. And so, Josh, what's like the most important things that people should do or think about in the process?
So I think one thing is a lot of other states still call what we call the personal representative an executor or executrix. And so the more common term for a lot of people is they'll say, I'm the executor, the executrix of my parents' estate. And so in the state of Florida, we call that a personal representative. And oftentimes when you're looking to avoid the probate process, as Doug said, there's certain assets that may not have to go through the probate process because maybe they had a beneficiary designation or they had a joint owner or something to that effect. So just because somebody's passed away doesn't mean we're going to have to probate every asset of their estate. But if we have real estate and it's owned in that individual's name, typically that is going to have to be probated in the state of where the real estate is. So if somebody owned a house in another state and in Florida, we might actually have to do two probates in that scenario, which means you have to have a separate probate, separate attorney in both states to administer that. And so if you're avoiding probate, you're avoiding the probate in multiple states, which makes it nice. Now, in the state of Florida, we also have the ability in some circumstances to do what's called a ladybird deed or an enhanced life estate deed, which means we can put basically a beneficiary on a deed to avoid the probate process. Now, once again, I say that cautiously because yes, that can avoid the probate process. But if a beneficiary inherits it and that beneficiary is going through a lawsuit or bankruptcy or a divorce or a creditor dispute or even in their own personal long-term disability, the asset might have avoided your probate, but it might be attachable by their third-party creditor. So once again, we wouldn't want somebody just to go out and do that without talking to legal counsel, but that is a way to avoid the probate process. Now, once you've hired the attorney and the attorney has prepared the petition and it's been filed, as Doug said, it's very much a waiting game. The letters of administration I think the soonest we've ever got them was probably about a week and a half or 2 weeks. The longest it's been several months, right? And so there's no guarantee of how fast somebody can get letters of administration. From a real estate perspective, what we oftentimes will see is a family member will come in and say, my mom, dad, somebody's died, I'm the executor of the estate, I've already hired a real estate agent, I've already got a listing agreement, and it's going live tomorrow. And we have to inform them, you can't sign that listing agreement, you don't have letters of administration yet, you can't sell the property yet, you don't have letters of administration. And normally that frustrates the personal representative or executor, it frustrates the real estate agent, and it frustrates the future buyer. Yep. And so the recommendation is although we all want to get those properties sold, it's actually take a step back, slow down, and make sure that we follow the process to a T, so that way nobody is getting frustrated along the way, and then that way the family does have the ability to liquidate that asset, but we're not creating problems along the way.
You bring up a really good point about the sequence of events that need to happen, but timing is really an interesting component to this as well, because in Florida we have a lot of the heirs don't live here, right? Their folks came down, they purchased real estate in the state of Florida, and then now we have this assets that needs to be dealt with, needs to be handled. And the time constraint around it creates an interesting component to all of this, because being in real estate, like we see situations where, for best case scenario, 6 months out through completion, or worst case scenario, 2 years worth, or 2 years of time, Mother Nature doesn't stop, right? And so Mother Nature is going to want to continue to unravel the house. And so, with air conditioners going out and roof leaks and all the things that happen in normal real estate seem to happen more often in scenarios where nobody's living in the house, nobody's checking on that, et cetera. And so that's one of the things that we at Gulf Point Properties do, is we actually provide a service to be able to help that by being the boots on the ground and checking on the real estate while, if you're out of town. We've seen that as a big gap in, because at the end of the day, like, everybody's goal is to get the most amount of money that they can out of that real estate. And if it's just sitting there not being taken care of, it's really at a detriment of everybody's total goal. So that's something that is really big. Anything else that people should consider in terms of the real estate component to this?
I mean, I would say, number one, you want to keep the electricity on, right? And so normally you need to get the electricity moved into the name of the executor. Mm-hmm. That way the bills are being paid by the estate. You want to make sure that if there's HOA bills, those are being paid. We don't want liens against the estate, against the house if the property is going to be sold. Yeah. If there's things that need to be fixed up on the property before it's sold, if you go out and start signing contracts with contractors, but you don't have letters of administration yet, and you don't have access to the money in the estate yet, there's complications sometimes to be reimbursed, or there may be a timeline before you can be reimbursed. So once again, our guidance would be wait until you get the letters of administration and you have access in the estate. Mm-hmm. Now, once in a while, like a couple that we're dealing with right now, the biggest asset and really the only liquid asset was a bank account, and it wasn't very large, which means you have real estate, you have property taxes, you have insurance, you have the light bill, and there's no money in the estate. Mm-hmm. And the house may be passing by homestead, which, as Doug was saying, is technically outside the probate estate. Mm-hmm. And so you have a third party that is having to front those expenses, but now those expenses are a debt against the estate, but the house is not an asset in the estate. And so listing a house that was a homestead for sale and making sure that the person that was fronting those expenses is going to be reimbursed is a very sensitive issue that has to be handled, and it needs to be handled the right way. Otherwise, if the house passes to those family members that aren't involved in the process, there may be no mechanism for that personal representative to actually be reimbursed for all the expenses that they've front-loaded. And
that's a big deal.
It's a huge deal. And so there's times people have fronted property taxes, insurance, and all these things, and then the property passes, and they say, well, where do I get my money? There's nothing to pay you. Their only option now is to go beg and plead their family members. And so that's why working with a law firm that's taking the time and the diligence to do it right is the best way to make sure that person has the ability to be reimbursed for those expenses.
And having an attorney a part of this is critical. I mean, it's a huge component of this, knowing how the system works. What would you say is important? Because Dorsey Law Firm's been around for a very long time, an amazing reputation here in Southwest Florida. But let's say somebody's outside of Southwest Florida. What are some of the things that they should do to interview an attorney to make sure that they've got somebody good on their side?
So I think it's a couple things. Number one, there's about 18 different counties in the state of Florida we will file in. There are certain counties we will not file in because those counties are considered to be restrictive counties and they require an order for everything. And so if somebody's in one of those counties, we'll gladly refer you to somebody that's good. I would tell them reach out to us. If it's something that we can handle, we'll gladly tell them. But if there's not something, or it's a county we normally won't represent, we have people in those counties that we can send them to. But if you're going to go out on your own and you're really going to interview, you're looking for a firm that actually has a true probate department in this scenario. A lot of small practices, you'll have one attorney and maybe one paralegal, and they do estate planning, which covers, probates, wills, trusts, everything, and they may not have the full staff to push that probate process. And we already know the probate process is time-consuming and it's expensive, and so if we don't have a full team that's working on that file, it can sometimes extend out the time period that it's going to take to probate the estate. And so the goal is to make sure you're working with a firm that has a full team, but as we always tell people, it's not a fast process. You have to be patient, and there's going to be waiting periods that you're going to feel like the attorney isn't doing anything, and in all reality, the attorney may not be doing anything because we're truly in a 90-day waiting period for creditors, and I know the beneficiaries are always looking for their inheritance as fast as possible, but it is a court process, and so we do have to take the time to follow the timelines that are in the statute.
So, I mean, your main office is located in Lee County. Are the court systems behind, like generally behind on seeing the cases, or is that pretty streamlined at this stage?
I would say it's fairly streamlined in Southwest Florida.
Okay.
There's some other counties that are a little bit slower, just kind of the way their structures work inside their own judicial branches. But in Fort Myers, Charlotte, Collier counties, they're usually fairly quick on turnaround times. Okay. Of course, in Florida, we have a very heavy season. Mm-hmm. So, during season, it can be a little bit slower. Mm-hmm. But for the most part, particularly in Lee County, we have a pretty good rapport with the clerk's office, and are able to get things turned around relatively quickly.
Okay, it's good to know, because I hear stories in different types of cases where it's literally the courts are just backed up, mm-hmm. and that causes so much of an issue. But it's good to know that they're streamlined.
Well, I think it's good to know. I mean, judges are humans, right? So they get sick, they go on vacations, and because they work for the government, they get long vacations, and so they will be away for a time period. And so in that scenario, your judge may not be working for a number of weeks. So if during the holidays, they're shut down, right? And so those things definitely slow down the process. And so in that scenario, there's no way for us to speed up a file. So if a judge does fall behind, or whatever the situation is, we're at the mercy of the court, literally, in that scenario, that we're waiting just like everybody else in line.
Got it. And as far as compensation for your services with that, is that something that's on the front end, the back end, throughout the process? How does that?
So typically, compensation is done as far as fees, mostly on the front end, okay. And then as expenses come in, a lot of times we front expenses for the process. As you can imagine, there's filing fees with the court. There's documents that need to be recorded. There's fees for mailers, things like that. So all those fees we usually typically front, and then basically invoice at the end of the process.
Got it.
And then really just depending on the complexity of the cases will depend on how much those invoices end up being.
Yeah, and let's say you have an estate that primarily have real estate. That's sometimes an issue, right? The personal representative says, I don't have the money to pay you up front. Mm-hmm. The only asset we have is real estate. Then at that point, we will assess our fees against the real estate when the real estate is sold.
Sure.
But once again, that's a conversation with the personal representative. And if it's a homestead property, sometimes we have to get that consent from the multiple parties that are going to inherit that property. And so once again, it's something that has to be talked about and negotiated on the front end to make sure the paperwork's in place, to make sure the administration is done the right way.
Mm-hmm. So in terms of the title portion of the process, sure. Because there could be some clouds on title and all of mm-hmm. that, is there anything to consider there?
Yes. So when you're trying to sell a property that's going through probate, particularly if there's a rush for trying to get liquid assets out of the estate, we recommend communication with the title company pretty early on in the process. We very frequently use Florida Freedom Title. We have a very good working relationship with them. They understand what we need. They understand what they need to provide us. Typically speaking, when you sell a property that's in probate, there's additional documents that might be needed by the court. Mm-hmm. So learning that early on from the title company is very beneficial, so we can work on those documents before the closing date. A lot of times, if you're using other title companies that aren't as familiar with the probate process, they'll review documents a week or 3 days before closing, and then tell you that they need additional orders from the court or things like that. Whereas if you know kind of when you open and put the property on the market, you'll have some additional time from the attorney and the judge to review documents and sign off on what's needed by the underwriter to
I wish I didn't feel the amount of pain from you saying that some title companies wait until 1 to 3 days before closing for the the final look. But I have been through that. We've been through that exact experience, and it's just here's the problem. Like, it's just no fun for anybody, right? Nobody likes surprises when it comes to especially real estate closings. And probate, if you've waited this long and you're almost to the finish line and you have some kind of a hiccup like that, it's just, I don't know, this is detrimental. It's terrible. So that's really good advice. And Florida Freedom Title, they do a good job. We use them here locally as well. So that's cool. Great. So you're probably getting an indication here that this is, probate's a complicated process. There's a lot of steps, a lot of stages to it. And so that is, that's the number one reason why I wanted to do this, is to be able to put some true professionals, true experts in the field here. So Doug, Josh, I really appreciate you guys jumping on with us today, and have an awesome day, everybody.